Hello, good morning. I'm Stephen Colby, and this is my webinar on how to protect your intellectual property, hosted by Rob at Idea IPO. Thanks, Rob. We appreciate this every time. I'm going to be talking today for about an hour, and then I will answer any questions you have. If you have questions, please put them in the Q&A panel. And after my presentation, I will jump to that panel first before answering to answer questions for a while. A little bit about myself. First, I am a patent attorney. I have been doing patents for over 30 years, but the first half dozen years of that was as an inventor. I started working for a patent law firm in 2000, and they helped put me through night school at law school. And I graduated from Santa Clara University. This is not Santa Clara University in the background. But I went to law school and have been working as a patent attorney since. For most of the 90s, I was a CTO of a chemical instrument company building instruments bought by big companies like Varian and HP and stuff like that. So at heart, I am truly a product manager. I'm a partner at Ramon Law. Ramon Law is a semi-virtual law firm. We have been a semi-virtual law firm for about 16, 17 years. And that means that we do have physical offices, but they're mostly admins and conference rooms. Most of the attorneys work at home. I work mostly in Reno, Nevada, but also spend about a quarter of my time in San Francisco Bay Area. So that's it. I do patents on just about everything. If it's deep biotech RNA viruses, then I have a partner I hand that over to. But we can do everything. Ramon is a full-service law firm. And just so you know, I saw these other people coming in. So we do have offices in Dubai and in London and in Boston, near Ventura, probably not Ventura, maybe County, probably. But we are a full-service law firm and do everything for startups. Speaking of startups, my talk today is going to be directed at early-stage companies that are trying to get a start. Typically, the clients I work with are companies that are going to look for venture capital or other types of funding to grow more quickly. And so that means a Silicon Valley type startup, right? If you are a flower shop or a plumbing company or an ice cream maker, I have actually had 3 clients in my career that were ice cream manufacturers. Yes. Yes, there is technology in ice cream manufacturing, but and you're not looking for venture capital, this will be useful in terms of protecting your IP, but not quite as useful as it would be if you were looking for investors, right? So let's get on with it. How to protect your intellectual property. So the first question, let me make sure I get this button working. Oh, look on the other side of my camera, boom. Okay, why would you do this? Right? Why would a cash-strapped startup with very little money be interested in putting their few dollars and lots of effort in intellectual property? Okay, and this is a really important question to start with, and it's something that you should be discussing with your IP attorney. Why are you doing this? And the answer for a startup is that you want to increase your valuation, right? The idea of patents, if I do my job right, the idea of patents is for you to get a better valuation every time you raise money, and especially on your exit, okay? That is why an early stage startup is going to develop a patent portfolio to increase the value of their company. The answer is not to clobber competitors, right? You are assumably a relatively early stage startup, and I have bigger clients like Facebook. But a patent litigation is a multi-million-dollar project. I have a litigation right now that I'm hopefully is just concluding. The final settlement agreement could be signed any week now. It will be 9 years old in December, this litigation. So if you are a startup and you start engaging in patent litigation, you pretty much become a patent enforcement company rather than a startup because it will consume you completely. And that's not what investors are looking for. Investors would prefer to invest in a company that's going to develop a product and make sales and then get bought by a bigger company and make the investor lots and lots of money. Okay. So the answer to the question is, why are you doing this? To increase the valuation. Right? And that means that the patent attorney should have a really pretty good idea of the business that you're in. In other words, what is your long-term plans? Are there 2 or 3 specific companies that you hope to get acquired by? If that's the case, then your patent portfolio should look especially juicy, especially interesting to those companies, right? And you need to be able to explain this to your patent attorney, right? So that's the first question, okay? This will impact the patent strategy a lot. All right, let's see. Trying to find that button again. Boom. Okay, what can you get? Intellectual property. There's lots of it. There's copyright. There is trademarks. There are trade secrets, and there are patents. Since I'm a patent attorney, I kind of have a bias, and I'm going to talk more about patents than anything else. But it is important to cover some of the others. Copyright covers things like the layout of a website, images, icons, paintings, text of a book, the text of computer code, right? Copyright covers that particular instance. So if I write a computer program, that set of code is covered by the copyright. The functionality isn't covered by the copyright. To give you an example, I might be a wonderful painter, not really true, but I might be a wonderful painter and I draw a beautiful still life of a bunch of fruit, okay? I can get a copyright in that painting of fruit, but I don't get the rights to all still lifes with a bunch of pears in it, okay? So that's the difference. So copyright covers a particular painting of fruit. It doesn't cover the general idea of fruit in a painting, right? Same thing with code. Copyright will cover code written in Java. If it's written in C++ with starting from scratch, that copyright doesn't cover the new functionality. Doesn't cover both of them, right? Copyright appears automatically, right? So the employee who writes it, you don't have to register a copyright right away. You can put copyright on your symbol on your website saying copyright My Super Company 2025, right? That puts people on notice that the material is copyrighted. In order to enforce a copyright, you actually have to register it, which is a very simple thing to do at the Library of Congress. There's like a $25 fee or something. Maybe it's a little more by now. But you can register copyrights for songs or images or artwork or things like that quite easily. You have to register it before you enforce it, right? And if you find somebody's copied your website, you can register it and then enforce it retroactively. So that's not a problem, okay? Trademarks. Trademarks are to identify your goods and services, all right? So Ramon Law, for example, or Xerox, or Toyota, or Colgate toothpaste, those are names that represent a specific product or service, okay? And trademarks are something that it is helpful to register. You don't have to do it right away. And here's your first little bit free advice for this webinar is if you have something you're planning on using as a trademark, a product name, for instance, put a little TM by it on your website and write down the date you first did that. Right? Put it in your marketing literature with a little TM. That gives you common law rights in the trademark. And in most countries, China being a big exception, that gives you initial rights to the mark. Right? So later when you apply to register the mark at the US Patent Office, you can say, oh, I first used it on July 12th, 2025. Okay, that's the first use of my mark. And that you'll get some credit for that. Okay. So trademarks, you can register, which would give you the right to use the little circle R symbol in the country you're registered. Or you can just put a little TM next to it and spend your money elsewhere. Trademarks cost a few $1,000s. Trade secrets, another thing that is very important but often overlooked, right? Trade secrets are your pricing strategy, your customer list, your weighting on your neural network LLM algorithm, right? Uh, the data, the tricks to data pre-processing before you train your AI. Those are the types of things that are trade secrets. So, and people fight over trade secrets all the time. They're a big deal and they can be really, really valuable. The issue with trade secrets is the more you establish that it's a trade secret, the more valuable it is, right? So you should have a list of what you consider your trade secrets. You should write a page down on each one of them. You should actually have a program to limit access to a trade secret. So if everybody in the company, when you're 300 people, has access to the core customer list, then maybe that's not a trade secret because, heck, the secretary gets it. Everybody gets it, right? So well, you want to actually have a program where you control who does and who does not have access to information. When somebody's granted access, they have to sign off a little sheet saying, yes, I know this is a trade secret. When they leave the company, you remind them of what they signed. That way, it's likely that they'll remember that it was a trade secret. I always feel bad for the engineer who comes up with a cool algorithm to do something, and 4 years later, a different employer needs something really similar and goes, oh, yeah, I solved this problem before, right? But lo and behold, that was a trade secret. Is that engineer going to remember or not? Who knows? Okay, patents. Patents protect the idea of the bowl of fruit. In other words, for a piece of software, they won't just cover the particular implementation, but patent can cover the functionality. And that's why patents are so much more valuable than everything else. So probably 70 to 80% of what I do are software related patents. I do a plenty of medical devices and solar panels and batteries and dog collars and just about everything else you can think of, cameras, everything else under the sun, insect traps. Being a patent attorney is lots of fun because I get to do so much. Every week it's something different. Today, after this webinar, I am going to be working on a wearable device for breast cancer detection. Isn't that cool? Yeah, being a patent attorney is a lot of fun. So that's the kind of stuff that I work on. Patents is what we're going to talk more about right now. If you have any questions, how many we got here? 41. If you want more about patents, if you reach out to me after this webinar, I will send you a link to a recording of one of my presentations on how to understand the patent. Okay, and that's really useful. It's another hour and a half presentation, and it goes through a patent in detail and explains how to read it, how to understand what protection rights it gives you, and so on. All right, so let's move on. Okay, let's look at patents, of course, because they're the best, coolest, yeah. Okay, what common types of patents and patent applications do you get, right? There is something called a provisional. That is an application. It is not a patent. There's no such thing as a provisional patent. It's a provisional application, right? And I'll talk a little more about that in detail in a second. You can get a non-provisional application. That's typically sometimes called a utility application, and that turns into a utility patent, right? A non-provisional application can turn into a patent if you get it through the patent office, right? One example of other type of patent application is a design application. There's others. There's patents on plants. There's patent applications for international filings. There's a bunch of others, but we don't need to get into that right now. I'm going to go through each of these a little more detail right now. The provisional application is really nice. It is a placeholder. It's something that expires in 1 year, right? So after 1 year, the provisional application goes away. And what you have to do is file some sort of non-provisional application claiming benefit and priority to that provisional within that year. If you miss that, you're in trouble. Okay, that's a hard deadline. A provisional application is a great way to establish initial rights. It's quick and easy, it's inexpensive, and we will talk about costs and budgets a little bit later, right? It only lasts a year, and you have to remember that. So examples of provisional applications are your slide deck attached to a requirements diagram for your software, right? Or a 3 or 4 page write-up done by the inventors. That's something, or maybe a thesis, a master's thesis, right? I've done those. You can take that document or those documents and put a provisional cover sheet on it and file it. And that gives you credit for whatever's in the document on the day you file it. You get a filing date for that material, okay? The problem with provisional application, let's say a slide deck, you might file a bunch of stuff like this just before you go out and start talking to investors. You get a provisional application, and then you start pitching your company with some amount of protection. The problem with the provisional application is it's usually very incomplete, right? It doesn't have a lot of elements you might want to talk about in claims. It probably doesn't even have claims in many cases. It doesn't have any technical details, right? Patents are about the technical part, right? I don't want a marketing document. That's really useless, right? Saying that I've invented the Star Trek transporter and I can zap you or beam you from place to place, that doesn't tell me anything about how you do it. I need technical details. So provisional applications can have issues there. Right? But then again, for an early stage startup, they're really useful because very often a company will change direction in a few months later. And you'll be really happy that you didn't spend the full amount of money on a non-provisional application. It just did some provisionals. And then you can file another provisional in your new direction, right? A non-provisional application is the application that develops into enforceable rights. In other words, it can issue as a patent, right? It lasts, if you pay all the fees, 20 years from the initial filing date, priority date. It is much more expensive, right? The reason mostly being is that it's prepared by a patent attorney, right? A provisional application doesn't have to be prepared by a patent attorney. A non-provisional really should be, or at least reviewed by a patent attorney, okay? So that's the process of a non-provisional application can turn into a patent anytime between 1 to 4 or 5 years, right? So there's a long process. The application gets submitted to the patent office. The patent office 95% of the time rejects it first time, right? And probably the second time. The average application gets rejected at least twice. And either then there's more what are called office actions and responses that have to be done, which cost money, or the applicant gives up, or you get an allowance, one way or the other. Now, the design application is intended to cover the ornamental features of something. So a tire tread, a hubcap, the shape of the brawn toothbrush, right? There have been significant design litigations between litigations over design patents between Apple and Samsung with regard to their phones, okay? So my favorite design application is the Polycom speakerphone. It used to be when I met lots of clients in person, we'd be in a conference room and there would be this triangular shaped speakerphone in the middle of the table. And it was a great example because the first law firm I worked for, we did patents on that. And it turned out for Polycom, one of their most valuable patents was a design patent on that triangular shape. It was a great looking shape. The speakers in the middle pointed up and the microphones are distributed around the edge, right? That gives you a really big sound, okay? And now again, we're talking design, not functionality. But as you can see, design and functionality can be related. The alternative to that is kind of a flying saucer round shaped phone, which doesn't look anywhere near as cool on your conference table. Okay? So that was a really valuable patent. It sold a lot of speakerphones. Okay. Let's move on. All right. Boom. Find that button. Okay. All right. International patents. Will you rule the world with the, I judged a bunch of pitch this week as a big venture conference, and I was on 3 different pitching panels judging pitches, and I had at least one and founder say, and we have worldwide patents. Okay, no. There's about 196 countries in the world, and there is no way you would want to have a patent in every one. That would cost a fortune. Right? It's really expensive. Okay? Some places, there's a couple of countries that aren't even members of patent treaties that would be a big problem. Okay, so getting patents around the world is everywhere is not necessary. The organizations that do the most coverage are like pharmaceutical companies, right? They might get a patent in Malaysia or in Brazil or in Argentina, right? I do have clients that get patents in places like Tajikistan and Argentina and Turkey, but their business is agriculture, right? So they get patents where their insect control products are used in those countries. Okay? So you and your patent attorney will sit down and decide where to go internationally. You have 1 year to decide to whether or not to even go internationally uh, from your first filing date. And there's something called a PCT application. That's called a Patent Cooperation Treaty. And the PCT is basically just an option that gives you another 18 or 19 months to decide which individual countries or regions you can go into. There's a few regions like the EPO, which covers most of Europe. That's very useful, which means it's expensive, but you can get one application process there and then coverage in lots of different countries. Typically, you'll want to pick countries where you either have a substantial competitor or where you're going to sell a lot of product, you think, or maybe where there's a company that's going to buy you. So if you think Samsung is going to buy you, you might get a patent in Korea, South Korea, or you might, if it's Honda, then Japan. So often these are the questions about which countries you get. Typically, as a company grows, 5, 10 years down the line, it'll have a sprinkling of patents in different countries around the world, right? So if you have maybe in the first 4 years, 5 or 6 patents you file, each one of them might be in the US and maybe 1 or 2 or 3 other places. The cost of international patents is significant. Probably over the life of the patent, you're spending $50,000 on it, keeping it up, paying for foreign associate fees, so on. So the idea of having your worldwide coverage, almost 200 countries, that's not practical. It doesn't make sense. So you won't rule the world, but you will get all the major markets, and you will make it very difficult to compete with you, right? Or when your acquirer buys you for hundreds of millions of dollars to compete with your acquirer, right? They will value that. I have seen cases where a patent portfolio made the difference in the acquisition of a company. In other words, there were several companies in that space, and there was one acquirer that was going to buy one of those companies. The case that I'm thinking about, the acquisition was almost $400 million. The competitor closed their books and went out of business without an exit, right? Part of the reason for that, not all of it by any means, but part of the reason for that was having an earlier and better patent portfolio. The competitor really hadn't paid attention to IP, but my client they'd done a really good job and they had a great portfolio. I have to say, the other reason is that my client was a really nice guy and the competitor wasn't really somebody anybody wanted to work with. And I bet that also made a difference. I don't know the details, but yeah, it can make a really big difference. When you're being acquired by a large company, they will do a mathematical, calculation. How much will it cost us to buy this company? We like the team, we like the IP, we like the product, right? Or we could go and do it on our own. We have 100 engineers and reproduce all the code within months. Plus AI, right? We can reproduce all the code within weeks. Which way are we going to go, right? And at the bottom of the spreadsheet, there's a number, and that impacts significantly what they're going to be willing to pay for you. So very often the team is actually really important. They will be asked to stay for a while, but then the IP is, right? And making sure they're not going to buy a company that doesn't have so much IP and let their competitor buy the one that does have the IP, because then they're going to be in trouble. Okay, so again, the purpose of the patents is to increase the value of your company. All right. Let's see. I see some questions, and I will get to the questions after my seminar. Good. Somebody's listened and putting questions in the Q&A. I keep looking over here because I have another screen. So sorry. Let's get to this. Next slide. All right. When do you start? Yesterday. Think of the song, right? I don't remember who did that. Right away. I take clients, with one or two people in what I call half an envelope. In other words, they've written an idea down on the back of half an envelope. They haven't even filled the whole envelope up yet, right? That's when I start talking to people. That's preferable. It is usually just some, half hour free consulting. This is what you ought to do. Pay attention, so on. That's when it's nice, not absolutely necessarily, but it's nice to have some early filings before you start looking for funding, right? You can file those provisional applications. And again, we'll talk about budget in the middle in a minute. So getting early filing dates is really important. Most of the world is on a first file basis. So and I have seen cases in the last 25 years where it has been a week or 10 days difference in time between a competitor and my client filing their patent applications. So getting things on file early is really important. In the US, if you show something publicly, and public includes like showing an app on a smartphone, that counts as public use of not only what's on the smartphone, but the entire backend server. All right. So be aware of that. In most of the rest of the world, there's no 1-year grace period. Once you show something publicly, that public use is prior art against your patent application. In other words, it can prevent you from getting a patent on what you showed. All right. So, and again, public use could be a pitch event, right? If you demo your little robot in front of 30 investors, and anybody could have showed up as an investor, that's public, right? The law varies in individual countries. Exactly what's public in Spain, I don't know. I'm a US patent attorney, not a Spanish patent attorney, but generally you want to try to file before anything that's a demo, right? And of course, investors aren't going to sign NDAs because they see thousands of companies every year, right? They can't possibly remember what came from whom, so on. So no NDAs with investors. You will have to show some of your secret sauce to investors when you're trying to raise money. And it's nice if you have a filing done before that, okay? And the provisional can cover you, right? Okay. Well, I kept saying that I would talk about costs. So I'm going to throw up some numbers, and I know that most patent attorneys won't do this, but this is really ballpark, okay? Take this with with a pound of salt, okay? What's the cost? All right. So you can do a provisional application. There's a book by Nolo Press called Patent Pending in 24 Hours. You can get for Amazon. It's about $40, right? And you can read that book. When they say 24 hours, they mean 24 hours of work, not one day, okay? But that'll get you a provisional filing, right? That's kind of the minimum lowest budget thing. If you work with a patent attorney, like me, I will help you get a provisional filed probably around $3,000. I can do this for a flat fee. And that includes, right, meetings with you to go over the technology, decide what to patent and what not to patent. It means going to writing a set of claims for you, doing some drawings, like helping getting drawings prepared, writing a summary, giving you an outline and saying, fill in this outline, right? And I've probably spent, 5 to 8 hours, something like that, who knows, on the project. And then, which is a pretty good deal. And then we file that as a provisional application. And that means that provisional is designed to have enough support to really count, to make a big difference. Okay, it's going to be much more thorough. It's not going to have words that actually limit you in unexpected ways, right? So a provisional application should cost you a bunch of time, and anywhere between, $100 and 3,000. That's a typical cost for a provisional application. So if you're an early stage startup, you should have that amount of money. This is designed for it to be affordable. Okay, if you don't have $3,000, you need to save up some money and put 50 or 100 grand in the bank before you do a startup, because if you have no money, the investors will realize it and your terms will be horrible, right? You'll be desperate. So don't go that direction, right? Now, a non-provisional application is much more expensive because a patent attorney has spent anywhere between 20, 30, maybe even 40 hours working on it, okay? So you can expect it to be getting close to $20,000. And that, the cost is directly proportional. I often charge by page. The cost is directly proportional to how much you get, right? You can go into a patent attorney and say, I only have $15,000. Do what you can for that much. A good attorney will say, yeah, let's figure out what's most important. So after you file it, right, and there's filing fees and other things on top of that, patent office fees, a few $100s. Then you go into what's called prosecution, where you try to turn your patent application into a patent. Okay, and as I said, most applications are rejected a couple of times on average, and so you probably are going to budget maybe 10 grand, 10, 12 grand more for that over several years. Okay, maybe 3 or 4 years. Right? And so getting your patent out is, your first patent is probably $30,000. And you celebrate and everybody goes home, you have a special happy hour. Then there's maintenance fees to pay. In the US, they're every 3.5 years. There's some fee to pay, so there's a little bit more money down the line, but now we're talking years out, which you don't care about now. So patents, though, can be parts of families. So literally today, I'm working, as I said, on a breast cancer detector, and I'm going to be filing the probably third application in this family, which means I've already written 40 pages, 50 pages, and I'm going to be adding 10 pages to this application, and which is on a new aspect of the company's inventions, but they're all related. And so I'm only adding 10 more pages, so it's much less expensive. It'll be less than 10 grand. It'll probably be less than 7. Okay. So even less than 5, who knows? I'm not done. So family members, and I have looked at clients of mine where we've done, 30 patents and looked at the average cost of getting them filed. Because the daughter applications, the related applications are so much less expensive, the average cost comes down to under $10,000. Okay, so that's what the pink line here is. It gets cheaper, right? The more you do. All right, that's patent costs. Okay, next thing. Let's do. Mistakes. Oh yeah, I have a whole webinar on this. Okay, so I can talk for an hour just on this slide. And I'm going to go through these a little bit. First thing I want to point out is the ownership being there twice is not a typo. Ownership is both the first and the second most common and serious mistake. All right. There's waiting. That means, we released our product 11.5 months ago, and it's a real success. So now we want to file patent applications on it. Good luck. Yeah. Right. You're giving me 2 weeks, maybe, only in the US. Yeah, not good. And then a lack of strategy. And finally, not really understanding the patent and what it means. Right. So I'm going to kind of go quickly through each of those items now. All right, ownership. Okay. Ownership of an invention initially vests in the inventors. Okay. You have to assign the invention to the company. There's a formal process, just like when you buy a house, there's a recording system. So anybody can go and say who owns a patent or a patent application. So this means you have to have an assignment clause in any employment agreement, in any contractor agreement. If you're using Fiverr, there's a little box to check that adds an IP clause to the contract. If you don't check that box and you have the person from the Philippines design your company logo, you've gotten the logo, but they still own the copyright. Big trouble, okay? You got to check that box, right? So anytime you hire anybody, consider the IP implications, right? Whether it's a contractor or an employee. And many things like code houses, they are very picky, right? Because they have tools that they're going to use and they're going to build something that they're going to use for you, but they're probably also going to use it for somebody else. So you have to have a talk with them and be very specific about what it is that they're going to give you. Okay, it has to be specific to your product. And having an IP portfolio beforehand is useful. Okay. Lots of people come up with ideas. Well, my favorite example is Adobe Forms, right? Adobe Forms is something we all like and use. It's really useful. I can send somebody a PDF document with a form and they can fill it in and send it back to me. Wonderful. That was invented by a sales guy at Adobe, right? So presumably part of his employment agreement said that any inventions he makes, and he hopefully gets a nice bonus, but are assigned to the company. If they didn't have that agreement, all of a sudden they'd be negotiating with him about how much royalty they're going to give. Okay. If you work for a university or a public institution of some sort, there may be an IP policy that you are subject to as an employee or a student. Okay. If you use university equipment, the IP is going to be owned by the university. They're going to have a say in how it's used, right? Okay. So the reason ownership is twice in mistakes is you want to make sure that you've obtained ownership in your IP. And I have seen companies that have gone 3 or 4 years with, and then like, oh, we forgot to get an invention assignment from our CTO. And all of a sudden the CTO says, I want 30% of the company, right? And everything falls apart. It's a cluster thing, right? You know what I'm talking about, right? So I have seen, even after investors who should have done due diligence on this and tracked all the assignments, this company screwed it up, you know, and it's like, oh my gosh, you guys need to get this signature. Otherwise, you're paying me to write patents that are owned by somebody else. Okay. You got to understand the assignment process. It has to be registered properly. Assignments have to be registered or recorded properly at the patent office. The reason ownership can be there twice is you have to worry about other people's IP, okay? So 2 ways ownership can kill you. Not owning your own IP is number 1. Number 2 is having somebody else's IP show up in your code or in your product or on your website, right? Don't use, you know, go find a nice picture on the web and put it on your website, right? Make sure that it's royalty free, or you go to Getty Images and pay the $30 royalty for it, right? You have to do that. You have to worry about engineers who come over and say, "Oh, I'm going to just use the code. I wrote this at my last, 2 jobs ago. I'm just going to grab that code, which I kept a improper copy of, and I'm going to plug it in here and take a week in Tahiti, right? And look what I did, right? You have to make sure that other people's IP don't come into your products, right? If you use open source, you have to read the license agreement, right? Open source code or tools come with license agreements, and those agreements can require that you make your own product entirely open source. So this happened to I'll say former president, but a current president with Truth Social. They released and used a lot of code from somebody else, and that open source organization came along and said, we remind you, you have 30 days to release your entire code to the public. And they had to pull the product back off, and it took them 6 months to come back up. So very embarrassing. Somebody didn't have lawyers. Surprise, surprise. Okay. So be careful with open source. You should have an attorney review the license agreement, make sure it's suitable. Sometimes the agreement can say, yes, you can use our code, but not in a commercial product. right? Only if you give it away for free. Not good, right? Okay, that's ownership. Be sure to cover ownership. And why did I put my boom? Okay, strategy. Okay, we talked a little bit about why you're doing patents. It's to increase the value of your company. This means that you want to patent stuff that's important to the marketing person, not necessarily the engineer. So if you're a two-person company, you got to take off your CEO hat and put your director of marketing hat on. Say, why are people going to buy my product, right? What am I pitching to my customers? It does this that nobody else can do. Or you're telling investors, we're going to be your next unicorn because we've got blah, 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 right? Those things that you're trying to sell the company on or sell the products on, those are the things that you want to get patented. Right? It should be, the patent process should be product driven. So something that an engineer thinks is really cool, I figured out this great way to do blah, blah, blah. But if it doesn't impact the sales of your product or the value of your company in some other way, that's not a priority to patent. Okay, maybe it's going to be a trade secret, which is nearly free, right? If you do it right. Okay. If you develop a patent portfolio over a few years that really relates to the reason your company is going to be successful, when you're doing your A round, right, and you're raising $20 million, I will give you a slide that shows those silver bullets, those magic things that are making you so successful in what's called a cluster map with all your IP. And it's basically a spider web. Like, here's the 3 or 4 things that have made us such a success. And here's all of our IP related to that. And the investor goes, whoa, awesome, right? I can really see how the IP relates to what makes your company important. Okay. And this is a quote. Did I put a little TM by this? Make the more IP, in some slides I have it. Make the IP more than just a checkbox, right? You need to convey to the investor. You have to have a strategy. Hold on. Has anybody figured out where this background is? All right. You have to have a strategy that builds up a portfolio that is going to look really valuable to an investor and an acquirer. So if you know you're going to be bought by Honda, fine, or the firm, I think, you want to develop a patent portfolio that takes your improvements into their ecosystem, right? And they'll look at the patents and go, oh, yeah, that's exactly what we're going to do with it. Oh, yeah, we really should pay for these guys. Okay, so that's the trick. You got to have a really good strategy. And in order to do that, your patent attorney has to understand the business. Like, what's your exit plan? Why, what's your product life roadmap look like? These are all things that are important for the patent attorney to understand if they're going to do a good job with claims on your patents. All right. Oh yeah, we talked about this a little bit before. Other people's IP. You want to be, there's 2 viewpoints about knowing about other people's IP. If you work for a big semiconductor company, they aren't going to want you going through the patent literature and finding patents that they infringe. Because if the company or the employee knows about those patents, it increases their liability on infringement. So if you work for a big company, don't go searching through the patent literature. If you are doing an early stage startup, and of course I'm from a science background, right? I was taught to read the literature. I go to, spend 3 hours a week in the library looking at what's going on in your field. Right? That's the startup point of view. You want to know what other people are doing. Because if you find somebody's patented all over something, then maybe you need to pivot, right? Or maybe go buy the IP portfolio or decide if you can use it, or license it. You don't want to spend 3 or 4 years of your life just, and you've and the life of 20 other people, and then all of a sudden get hit with a patent lawsuit you're never going to succeed on, right? You don't want to do that. You won't get sued until you're super successful, and about a month before you go IPO, there'll be a lawsuit that comes in, and you have to settle it before the IPO, and they're just going to ream you, right? So know what's out there because you can be agile, flexible, right? The big semiconductor company can't really change if they see something and that's going to be a problem with their next product. It's kind of hard for them to work around it. But you, as a agile, cool startup, you can say, okay, we're not going to add that feature. Instead, we're going to go this way. We're going to work around that pattern. Okay. If you read the literature, you might find something and go, hey, they're doing this, but they're not doing it quite right. If they knew what I knew, they'd come up with this answer, right? Which is even better. So you'll get ideas, right? And you can patent those ideas, those improvements, right? And block the development of a competitor. Okay. So read the literature, keep records. Oh, I can't. I don't have a notebook next to me, but I have a notebook. It's a little yellow bound notebook I'm carrying around nowadays. I go to meetings. I write down my notes. The good CEOs I know keep notes, right? Every meeting, you sit down with them and they pull up on a notebook and it's meeting with Stephen Colby, blah, blah, date. It helps you in so many ways. I'd like to give an example here. Let's say you have a meeting with a bunch of engineers and you've come up with a really cool new feature. You're a self-driving car company, right? And the new feature is something that lets the car rise up above all the other cars on stilts and roll down the roadway and drop back down again to miss the traffic. Okay, just hypothetical, right? And you write down your notes. Karen had this great idea. She's figured out how to have extending wheels, and this is going to be fantastic. And you've got it in your notes, and you saved it and everything. Um, 2 months later, you hire a whole bunch of engineers. One of them comes from a competitor. A year later, right after you've released your new extended wheel rising car invention, the competitor sues you for trade secret misappropriation. And, oh, those extended wheel were really our idea, and you got it from the employee you hired, and we're going to sue you and her, and you're going to spend the next couple of years in court. Okay. Well, your notebook turns this from a multi-million-dollar issue that could kill your company into a maybe only $20,000-$50,000 issue. Okay, because you've got good records, right? Another example, you have a meeting, people toss around a bunch of ideas. You see that John and Linda talking back and forth come up with a cool idea. You write that down in your notebook. 8 months later, there's a question, who invented this? Who's the inventor on this patent application? Well, I went back to my notebook and John and Linda came up with this, but Susan talked about this thing, right? Okay, so you have a record. Here's the best. You know that your patent attorney promised you to have a draft in a week, and it's been 10 days, but it's in your notebook, okay? That's very hypothetical, of course. So keep good records. Walk around with a bound, like laboratory type notebook or journal, and all your meetings, whether it's IP meetings or anything else, keep records, okay? Who agreed to what? These things that are important. And that is a habit you should develop if you're going to lead companies. All right, next slide. Okay, wait, next slide is, okay, this is out of date. It's only 12 countries now. We closed our Moscow office. But this is my contact information. If you reach out to me, what's my timing? Oh, pretty good. If you reach out to me, I will send you a link to my webinar on understanding the patent. And be happy to do that. Feel free to connect with me on LinkedIn. Yes. If you have any other questions, I'm now going to go through the Q&A first, and then somewhere on my screens, I have 3 screens. It's pretty good. Somewhere here, I might look at the chat, but usually I don't have time for that. Okay, so there's my email address. You're welcome to reach out to me. Ramon Law, again, does not just patents. We do company formations, mergers and acquisitions, white collar crime, if you should need it, real estate, aircraft leasing, family law, whatever, all over the place. Okay, that's it. Now I'm going to go to the questions. So anonymous, welcome. anonymous attends lots of my webinars, right? What happens when your provisional patent application becomes a granted patent and it ends up being prior art for competitors' patent granted on the same invention? Okay, so you file a provisional and then you file a non-provisional, which becomes the patent, right? And then you have a competitor that has a patent issue, right? And you realize, oh, the examiner screwed up, didn't see my provisional. We were actually filed 3 weeks before them, okay? And so their patent got examined before ours even published, so that their patent examiner didn't even have a chance to look at my stuff, but I'm first, okay? So pretty much their patent is dead on arrival. There's some steps you can take. There's processes in the patent office you can take to cancel somebody else's patent, right? And very often litigation starts with that. If you sue somebody on your patent, the first thing they'll do is try to cancel your patent, right? It's called an inter partes reexamination, IPR. And it does cost money, but it can be done. There's other things you can do. You can get your patent made of record in the files at the patent office of their patent. So anybody who actually goes digging and looking at their patent will see yours too and go, hey, wait a second, this was added to the record later, and it looks, yeah, it's prior art. So that will kind of defang their patent. They won't be able to get much money for it, and they certainly won't be able to enforce it. If they try to enforce it, the person they enforce it against is going to be able to turn around and sue them back and really nail them. So there are steps you can take, and this does happen. There are 12 million patents out there. And Google, literally Google is more of prior art. So it's very hard for examiners to get things 100% right, and very often they miss things, right? It's not always true. That's why you have to have a good set of claims in your patents, right? Because there's always some prior art. The question is it enough to invalidate claims? Okay. All right. Lisa, does your firm help advise companies on how to map out their IP? Yes, definitely. Patent and trade secrets and internal processes, yes. Even at a high level. I'm developing software with various partners, and it'll be a complex map out. Yeah, that's fun. We love doing that. So again, I mentioned earlier, I spent most of the 90s as a CTO, and I would spend a year on a project building an instrument, maybe a sampling robot for a chemical instrument. And so it would be the same project for year in and year out. As a patent attorney, which is really fun, right? You get to do literally a different thing every day. And working with early stage startups where you're sort of a relatively big fish in their little bowl is really fun. Certainly strategizing and finding a patent attorney that has a product development background is useful too, right? And talking about strategy and the competitive landscape, that's important. All right. So yes, Lisa, just reach out to me. I'll be happy to help out. Okay, what's the advantage of including claims in your provisional application? I like this question. The issue is that if you have a provisional application and then later a non-provisional, you want enough in the provisional to actually support the claim of the non-provisional, right? By support, again, there's a set of claims in a patent and there's the write-up, the specification, which is all the description. The claims say what you think is yours, what you're claiming as your invention. And the rest of the write-up it might be, a lot of background, but it's supposed to explain the meaning behind the claims, right? It's supposed to explain the invention and support the claims, all right? So if you do a provisional that's really thin, right, there's not much technical detail in it, and it doesn't have claims, and then later you write a non-provisional application and you have the data tree traversal logic, right, is a claim element, but you haven't mentioned that in your provisional at all, then that claim isn't really supported by the provisional. So I like to put claims in provisionals to make sure that everything in something I might want to claim is at least touched on in the provisional. right? So I can say, hey, look, here it is. And what I'll do is I'll write a nice set of claims, and then I'll take those claims and I'll copy them into the detailed description and make the claims into an outline and say to the inventor, I want you to write a paragraph on every little thing here, at least a paragraph, right? And that way, I know that at least for that early version of claims, there is support for it in there, and you'll really get the value out of the provisional, right? If you have a slide deck that kind of touches on your secret sauce, but doesn't go into any technical detail. Like again, here's the Star Trek transporter. You sprinkle, the little lights flicker here, and there's a sound, and boom, you're over here. Maybe I should switch that. Let's call it a TARDIS, right? It's a TARDIS. You in time here, and all of a sudden you're at a different time, and there's this whoosh whoosh sound. Okay, you might have that in a pitch deck, uh, but in these cases, the investors are going to ask for more. But it doesn't give enough technical detail to support later patent claims because you haven't explained in enough detail. The requirement, the standard is that you explain enough detail in the document that an engineer of ordinary skill in the art could reproduce it. So you can't have a whole series of steps, then a miracle happens, and then a bunch more series of steps, right? So that you have to completely explain the invention that you're claiming. And in some areas, like in biotech, this can be a real issue because if you claim a whole genus um, of compounds or of DNA structures, but you don't explain all of them, you might have a claim that's not supported properly and could be canceled on that basis. So yeah, that's why I like to have claims in provisionals. It always guides you to make sure you've covered at least the basic stuff. So in that provisional might have the slide deck for the pitch deck attached as an appendix, but yeah, I don't, that's just to make sure it was there. Okay, next one. How do you decide whether you need to file more than one patent application for technology you're developing? Very well. I do about 5% of my time is patent litigation, right? So I do patent litigation. The more a family of patents is infinitely better than a single patent. Yeah, exponentially better. Let me put it that way. And as your company develops, you will have an initial product, right? And then you're going to have improvements, right? Tommy? Yeah, it's not just one thing. And over the first few years, you'll have engineers working on all kinds of stuff. And a typical startup post-funding, meaning they've gotten at least $500,000 or $1 million, might spend 30 to 50,000 a year on intellectual property, right? That's a budget number you could put in a budget and investors would be okay with, right? You're going to develop more technology, right? So you'll get the core thing and then all the different improvements on it. And it might be that in a couple of years, you realize that somebody else beat you to part of the core stuff, but you have now all the improvements, right? So the idea, you want to cover what I call orthogonal directions. You want to cover your inventions from orthogonal directions. So here's an example, a sewing machine. The big invention was the bobbin, right? So you could loop the threads, right? Then there was the foot pedal, the trundle, right, which moves the needle up and down, right? Then there was the needle with a hole at the pointy end. Think about that. Before the sewing machine, nobody would put the hole at the pointed end of the needle. They put it at the fat end, right? Who would put it at the sharp end? Why would you do that? Okay. But in the sewing machine, it's a requirement. So if you're going to patent the sewing machine, you patent the bobbin, you patent the gear system for the up and down movement and the trundle, and you patent that needle with the hole at the pointy end, right? It might seem obvious once you've got the sewing machine in front of you, but it wasn't obvious before, right? Okay. A lot of the time, invention is realizing the problem and then saying, oh, nobody thought of this problem before, but I have a solution for it right away. Like put the hole at the pointed end. Okay, that's inventing, right? Realizing the problem and coming up with the answer to it. And after the invention, it may look obvious, but beforehand it wasn't, right? You just when you're doing a needle and thread, you don't put the hole at the sharp end. Okay, so that's an example. So you want to file, to answer your question, you want to file patent applications that cover your product, the sewing machine, from lots of different points of view. I call it some mathematical phrase, orthogonally, right? Perpendicular, right? So that if one gets knocked out, again, by some piece of prior art that you didn't know about, or some other thing, you still have a whole bunch of other legs to stand on. And a product that's 10 years old might have 20, 30 patents around, right? That have been slowly evolving and following improvements in the product, right? I think, let's say last year, probably in 2023, I filed patent applications that had priorities going back to 2005, right? A family, right? And those were going to expire this year, right? Like in a month. But they were really valuable, so we did it. Okay. So those are the types of things that that's why we have more than one. And again, you can have one specification, right? One 60-page document that supports lots of different claims, right? There could be other, other areas of the invention that you can claim, and you'll end up claiming lots of things. So that's why you want a whole family of patents. Okay. All right. The provisional application becomes effective. The question is, when does it become effective? It becomes effective on the filing date, the date you submit it. You'll get an electronic filing receipt, and that is the day you get credit for whatever's in that document, right? If it's a really thorough document, that's wonderful. If it's only 2 pages, then you probably have a problem. You better add more. Right? And you can file a whole series of provisionals, like 5 or 6 during a year, and then convert them all into one big non-provisional application. Right? So it can be that as the year goes by, you come up with more and more ideas, and you call your patent attorney and say, we just had this next idea, here's 5 more pages, add it to our existing document and file another provisional, right? And claim all those half dozen provisionals when you go to one non-provisional. Okay, next question. If we publicly tell a venture capital investor that we build a new A model architecture software, and we publish only the performance metrics trained on blah, blah, yes, as accuracy does this, that is not public use. But if you give them any type of demo, it is. I'm going to tell a story here. Right, I still have time, right? Yeah. The law for this comes from the 1800s, and it wasn't AI back then. It was women's clothing. There was a case where an inventor had designed a new corset, right, which shaped the woman's profile figure, right? And it involved some whale bones or some new structures, to keep the shape right. And he had his wife wear this corset out in public. Of course, she had a dress and whatever else they wore back in the 1880s out on top of it, right? So nobody could tell that there was a corset, but they could see the effect of the shaping, right? And that was considered public use, right? Now, fast forward 150 years, and you have an iPhone app, right? You have an iPhone app with a bunch of code on the phone, but then a back-end server that has neural networks and a whole bunch of stuff on it, right? The operation of that app on the phone is supported by the neural network or the entire back-end server, right? Off in the cloud somewhere. So you're demoing the entire thing. That's the whole thing is being made public because the effect of the server appears on the screen of the app. Okay, so if you tell them that this, and to answer the question here, if you tell them the characters, the features, or the capabilities of your neural network, that's not a public demonstration. Okay, that's data. They're not showing that being used. Okay, so you're probably okay there, but I would also worry a little bit because it might be that in the UK the law is different, right? It might be that in China, the law is a little bit different, right? So I'm a US attorney only, California attorney. So that's important. Keep that in mind. So it's always nice to, now, The actual, I do a lot of AI, believe it. The actual neural network itself will be a trade secret, right? The weightings and the data, right? Um, cool ways of pre-processing the data, for training, or building feedback loops for training, so that once the system's out in the wild, it continuously improves itself and learns more, right? Those could be trade secrets, or they could be patents, right? That's the type of thing I very often see in AI is, hey, we figured a really cool data feedback loop where we have home healthcare providers answering questions that are provided by the system with their clients who are elderly people, homebound, and we have a feedback loop that builds on the data here, right? I have clients where in the AI space that have been in the AI space for over 10 years, and their value is in their data, right? People want to buy their really good early data because that's where a lot of the value is these days. So patenting how you build the database and the training set is pretty common. Okay, next question. Hello, how to explore if there are already patents similar? Go to Google Patents. There are books. Nolo Press has a book on patent searching. There's ways of searching by classification. I would start off by trying to identify competitors, their principals, look for patents by them or assigned to those companies. You can search the assignment database. Do a search, read the literature. It's keyword searching at Google. You can also search at the patent office. I think I like Google a little bit better because it covers the whole world. And it'll cover non-patent literature if you want. You could have a search done. The searches can vary from, $600 or $700 up to 10 grand. So before litigation, somebody might spend $10,000 on searching their own patents to make sure that they're good before they spend hundreds of thousands of dollars on litigation, right? And the quality, the types of searches and the search qualities can vary widely. After you've done a search, even if you've done a $600 search, now you have a bunch of, you got 30 patents back and you're going to spend thousands of dollars having your patent attorney look through those, right? That's much more expensive than the search was. I recommend, and so I have a couple of clients that do searches before they convert from a provisional to a non-provisional, and I think they probably break even on that cost, probably save some time, but usually we don't. We let the patent office do the search, the patent examiner do the search. But part of it is that there can be unpublished. So if somebody filed a provisional last week and they decide in a year from now, they're going to file a non-provisional, that may not publish under some circumstances until it issues as a patent 3 or 4 years later, right? All of a sudden, a patent issues that has a priority from last week, which no searcher would have found, right? So there's unfindable prior art, which is an issue. Okay. So, but that's it. Searching is good. Does a patent attorney need to be specialized in the field of the patent? What about AI types? So my background is my PhD is in analytical chemistry and chemical physics. In the 90s, I was running a substantial commercial website for a chemical instrument company, and I was their lead of product development, what we would have called a CTO. I was the product development manager, which meant CTO. And I wrote a lot of code. I wrote in grad school and as a postdoc, I was writing code on, so computers, we were building boards using Wire App and putting them in IBM PCs and then IBM XTs, right, and building chips or circuits from 888 chips, right? I spent 3 or 4 years teaching electronics at the graduate school level, right? So I have a pretty good code and computer background. In industry, I was programming firmware for robotics and control systems. I've written, somebody asked me when I first started coding, and I can say it was about, I wrote a tic-tac-toe game on a PDB-10, and that was in probably 1970, 1971, maybe. I learned Fortran on punch cards. But back to AI. Yeah, I do tons of AI. Because you're a patent attorney and if you're working a lot in software, uh, you get all of it, everything, right? And I read up on it. I read books on it. The last book I read was on post-quantum cryptography, right? So these are the type of things that I focus on. That's the case. I'm still, a chemist, and an engineer, a chemical engineer, really. I build chemical instruments. I do lasers. I do semiconductors, machine process. A lot of our customers when I was in the industry were hard drive manufacturers like IBM back then and Western Digital. So we would make equipment to help them analyze and build their. But I do a lot of robots. Um, what other fun things? I've done dog collars. I've done escalators. I do lots of drones lately. Drones are big. I've been doing drones for about 4 years now. Um, uh, I had a customer that was a big indoor drone company, and they were Ukrainian too. So um, that was a client. So I do pretty much stuff across. I have about 40 patents of my own. Okay, next question. Uh, yeah, so if you are doing a, so I this morning I had a meeting at 5:30, yes, with Israel, and the technology was related to spinal cord repair, right? I would probably handle that, but I wouldn't handle it if it was a virus vector RNA. I have a partner who does that kind of stuff, right? Who does pure biotech. If it was a plastic, even though my background is chemistry, I'm not an organic chemistry. I would probably give that to one of my partners. Um, you want somebody who is in the area. It also makes a difference. Patent attorneys that are Silicon Valley based versus not, they have a different focus, right? Um, so somebody who's been a patent attorney all their life for 3M is probably not going to be good for your software company um, because they've done sticky stuff, right, or materials. Um, anyway, that's it. Sorry. Okay, anonymous. We saw a competitor obtain an II patent in the medical field, and we attempted to produce a working copy and discovered that the disclosure of the patent was not enabling. Yeah, there's no technical about the AI model architecture. Um, you have a bunch of questions here. You're saying that you think that somebody's disclosure was not enabling. Um, they only produced a data set, but not how they got to it. It really depends on what the claims are. In one aspect, are they claiming the actual AI data set that they haven't enabled, or are they claiming some result using it? Can you pay an engineer to be a plaintiff and litigate to get the patent canceled? We're talking budgets in the hundreds of thousands, right, to get it canceled. And if you want to know how to do it yourself, that's a really detailed question. You should sit down with a patent attorney and go over that. Um, so, and do an analysis, but it's expensive, right? Better, better yet, figure out how to do it and then file a patent application that does explain the details and patent those details. Then you're gonna have, anyway, never mind. Okay, okay. How is it that with composition of matter, a single patent can be very strong? Um, it depends on the composition of matter, but it can, right? I, let's see, my last composition of matter um, was a mixture of cannabinoids and olive water extract, right? Both very high antioxidants, right? So this company was taking cannabis and taking olive water, not necessarily the oil side, but the water side, and doing co-extractions. So that the water in the olives helped extract uh, the compounds they were interested in from the cannabis. And that combination made a really cool nutritional, anti-inflammatory thing. You can buy it. Okay. So the composition matter can be very specific, right? And if that specific combination is the key and any variation from it is not so good, then that's a strong patent. So if it covers a specific compound or composition, that's good. Another one that I did a ways back was in nano layering of carbon composites and carbide, which made an extremely hard surface, right, for tools and mining, right? That was one patent that was really strong because it covered completely the idea, the proper ranges of how you would turn on and off the deposition process. So you had 10 to 20 nanometer layers of materials that were pancaked, sandwiched, right, or laminated. And that was cool. So it can be. Yeah. And it's easier to find prior art with materials because the examiners in the chemical space, they can find stuff because it's scientifically organized. But okay. What is the cost for freedom to operate to be done at your law firm? So we would farm that out. We wouldn't do it ourselves, but I have contractors that would do a freedom to operate search for you. And I don't charge you any extra. I mean, their fee is just passed through. It can vary from maybe 1,000 to 10,000 or more, depending on the thoroughness of the search. And again, the problem with a search like that is there can be prior art, like the guy who filed the provisional last week, that you're not going to find out about until years from now, a year or two or more from now. So, but it can work. It can sometimes make investors happy, but really the good investors they'll know the competitive market space and who's doing what. So, if an investor demands it, they should pay for it. But it can be expensive. And I can answer specifically in your case, and I can actually refer you to, I'd have no problem referring you to organizations that'll do it. Okay. When you file multiple provisional applications in a year, extending the original provisional application, when does your non-provisional application covering all these have to be filed? On the date of the first provisional, right? So if you file 4 provisionals in a year, before the anniversary of the first one, you can file a non-provisional. You will reference all the ones you filed before, right? All the provisionals in that. You may file another non-provisional on the date of the anniversary of the next one. Depends on your strategy and your budget, right? So it could be that we try to get a bunch of patents. So the company has lots of money. We might file a non-provisional for each provisional, right? And go after them all at once in parallel. If funding is concerned, budget's always concerned, then we say, hey, we've got 4 inventions here. We're going to go after them one at a time. And we're going to keep this family alive. And first priority 1 is now. 2 years later, we're going to go and reach back all the way back in priority for the second provisional filing. We're going to file an application focused on that invention, right? So this spreads the costs out tremendously. In the US, you can do that. Overseas, it's a little more limited, but we can manage that as well. Okay. Can LLMs be helpful in patent research? Any cheap or free options? Yeah, there are. I have tried a bunch of the LLMs. You get something. If you want using it for drafting or claim generation, I can give you a specific example. So I was writing a patent on sails for sailboats. And the idea was to use smart materials in the sails so you could change the shape of the sails. Before ChatGPT, I would have gone to Wikipedia and looked for articles on smart materials and found all the smart materials there, and then just listed them in the patent provisional and said, hey, it could be any of these materials. I don't know which one's best or is really going to work, but I want to get it all in there, right? In case one of them turns out to be important. With GPT, I could go and say, give me a list of all the smart materials that could be used to change the shape of fabric, right? And it would give me a list, and I would copy that and put it in my invention. Now, the problem is, if the AI invents something, that could be grounds for invalidating your patent, right? The law on that is not clear yet. I have used AI demos of products specifically for patent drafting, and I write pretty fast. I mean, a double spaced page ready to file takes about an hour. So 20 hours, I've written 20 pages, ready to go. So it's, if I get an AI generated paragraph, it takes not that much less time because I have to go through it so carefully. And then the AI will have missed things that I'll think of, right? Right. There is creativity in this field, right? Um, so without being an inventor. So yeah, you want to do uh, you also have to be a little careful because if you submit a query to ChatGPT, that's not confidential, right? They can use that query for whatever they want, and it's not considered. I don't know if it would count as public disclosure, but I certainly wouldn't put anything in a prompt to a public resource that was a client, included client material, right? In the sale case, I could do that. I could say, change the shape of the fabric without revealing that it's sale for sailboat, right? But yeah, it's getting used more and more, especially in law, probably in contract review. Um, and it depends on the questions you ask. So writing a contract is one thing. Um, Submitting a contract to an AI and saying, what are the things missing in this contract? And the AI will come back and say, well, you haven't covered this, and you haven't covered this, and you haven't covered. And then the lawyer, with his lawyer mind, goes, oh yeah, you're right about that and that. Those two I really did cover. I'm not worried about them, but that helps. It's a tool, right? But for attorneys, we have to use very specific systems that are confidential, right? It can even learn from our prompts, because if I ask a query about one for benefit of one client, and the system learns from that, and that somehow benefits another client, that's bad, right? There's information from one client that somehow helped another. There can't be that, and so it's very sensitive in the legal space. But yes, it can be done. I have yet to tell a client to use AI to fill in a provisional, but that's probably going to happen in the next year or two. Yeah, but then they miss. I mean, the AI is not. If you ask the inventor to do it, there's so many more ideas. I mean, I want to compare. That's what I'm going to do. I'm going to have an inventor do one. Could be one of you, right? I'm going to have an inventor take an outline and fill it in, and then I'm going to do it with AI, and I'll I'll send the inventor the comparison, right? We'll see what happens. Okay. Next one. Getting near the end here. Last. What about academic publications and press articles? No demo. Yeah. So academic papers, put a provisional cover sheet on it and file it before submission, right? Even the review process is supposed to be confidential. It's often not. Having been in sciences, I can tell you, it's very often not. There's a great case where it was in superconductors, right? Somebody developed, and this is a good example of a material claim that was really strong, right? Because it was the formula for a superconductor. And so it went through the entire review process, right? And this was when higher temperature superconductors were first coming around. I'm going to be done in 4 minutes, I promise. And so somebody submitted this article, it got reviewed, and it was about to be released, and he was looking at the final galley proofs, and the professor, the inventor, says, oh no, that's not yttrium, that's something else, and changes that one compound, which changed the invention immediately, right? Because he knew that the reviewers would be the other people in the field, right? And he didn't want them to see what he was really doing. And it was kind of scandalous, but it worked, right? It's very common that a startup will be founded on work done at a university, and I will end up taking even a PhD thesis, putting a cover sheet on it, and filing it as a provisional application, just to make sure everything in there was covered, right? So, yeah, the filing fee for a small entity at the patent office is $130, $135. And it takes about half an hour for an attorney to do it. So it's easy. You can put in a cover sheet on something and filing it is easy, right? Okay. What do I call the updating strategy of filing multiple provisionals? Normal. Yeah. I don't have a name for it, but that's what I do. I think that's what most good patent attorneys will do. Especially because in the first year, ideas are growing, expanding, sometimes changing directions, sometimes finding out it doesn't really work. But yeah, and a patent attorney who works with startups is very budget conscious. So I will be filing something today on the breast cancer that is, as I said, probably the fourth or fifth filing built on the same thing. And every filing is another 10 pages, 10 or 15 pages of writing, right? And this is really useful. And at the anniversary, the 1-year anniversary of the first one, I will file a PCT application to preserve international rights. And that document will probably be 80 or 90 pages long. It'll be huge by then. So, okay. Again, there's my email and my LinkedIn. Please reach out to me. If you send me a request, I will send you a link to my webinar on understanding the patents. This has been recorded, and anybody who wants the slide deck or the recording, reach out. I will send it to you. Thank you very much. Have a good day. And thank you, Rob, if you're still on. All right.